Chairman, members of the committee, my name is Cathi Herrod. I am with the Center for Arizona Policy, and I'm also a licensed attorney. And I, like Mr. Howard, have been with this issue for many years, and we have done this routine in the past. I'll try to be brief and just make a few points regarding what's been said today. What we have seen over the last few years is we have seen a travesty in the state of Pennsylvania when state regulators did not adequately enforce the abortion laws in the state of Pennsylvania, and we saw many travesties. We also in this state last year had an undercover video at a non-Planned Parenthood abortion clinic that clearly showed that the clinic was not following the laws that you all have passed and have been upheld, and so that there was a need to find out exactly what is going on inside that abortion clinic. You have in the notes that it wasn't brought out in the testimony, but I want to just mention something that we heard in House debate and that is also in the comments that have been submitted to you online. And that is that this is once again going to cost the state hundreds of thousands of dollars in litigation fees, and so the state should not pass this bill because of what it's going to cost taxpayers. Just want to point out a couple of things. Indeed, there have been two provisions that you all have passed that the United States Supreme Court declined to hear for a variety of reasons recently that did result in litigation fees. But I think it's important to step back for a minute and look at what has been challenged that did not cost the state any litigation fees or any taxpayer expense. For example, Planned Parenthood challenged the Abortion Consent Act that was passed in 2009. They challenged that in court. It was upheld unanimously by the Arizona Court of Appeals. That is what means that today in the state of Arizona that we have expanded rights of conscience for healthcare professionals who do not want to have to participate or provide an abortion. It means that women have a right to have informed consent provisions 24 hours before they seek an abortion. It means that parents are guaranteed that the parental consent law will have some teeth in it. And for example, what happened in the past where a 16-year-old received an abortion on the basis of an email that her boyfriend sent from his high school computer cannot happen again because we now have a notarized requirement that was upheld by the courts. So when our staff did an analysis and we came up with, since 2009, there have been 25 different provisions relative to the practice of abortion that you all have passed that have not been overturned in court, they have not been ruled unconstitutional, and they have not cost taxpayers one dime as far as in litigation fees paid to opponents of these laws. So a 25-2 record isn't bad when you're talking about the need that a woman who is considering an abortion and walking into an abortion clinic should be afforded the same safeguards that she would be afforded if she's walking into any other healthcare institution in this state. And that's all that this provision is about. As far as our organization, we are as concerned about a woman walking into the abortion clinic as we are about her preborn child. And that's why we advocate for something that will indeed promote the safety of women, and it is a Women's Health Protection Act, as the bill sponsor mentioned.